The constructive trust arising from the agreement to purchase and sell property can be understood in the following way. Because of the nature and expense of land, almost all contracts for the sale and purchase of land are executory, meaning there's a significant time lapse between the moment two parties agree to sell and buy this parcel of land at this price and the date specified for delivery by deed. Some of the reasons for this time lapse are probably quite intuitive. The selling party might need to find another piece of property to move into. People have to make arrangements to move from one home to another home. People have to arrange for the financing of the purchase. The purchaser of land will have to investigate title, that is, make certain that the vendor actually has the title that he or she purports to be selling, and the purchaser may want to make inspections of the property. All that is to say that it's very, very ordinary to have a lapse of time, often 3 months, but it could be more or less, between the contractual agreement to buy and sell a piece of land and the time for performance, which is also called the closing date. At the closing date, the actual transfer of the property is accomplished by way of deed. In other words, by way of a document that is signed, sealed, and delivered that basically says something to the effect of, in consideration of a sum of X dollars, I now convey property X to so-and-so. So here's the issue that now concerns us. The time lapse between the agreement of purchase and sale and the moment of delivery of the deed at closing means that, according to the traditional principles of common law, until the moment of delivery, the seller continues to be the owner of the land in question, and the purchaser doesn't have any rights in the land. All we have so far is a contractual agreement to transfer property, but no transfer of the property. And the time lapse also means that there is time for one of the parties to change their mind for whatever reason. Changing one's mind under these circumstances constitutes a breach of contract, and at common law, the remedy for breach of contract is expectation damages. In other words, a sum of money. So I agree to sell Blackacre to you, and we agree that the time for delivery is 3 months from now. If I change my mind and decide to keep Blackacre or sell Blackacre to someone else willing to pay a higher price, and you sue me for breach of contract at common law, even if you're successful in your suit, your remedy at common law is not a court order forcing me to hand Blackacre over to you. The remedy at common law is expectation damages, the difference between the purchase price we agreed upon and what it will cost you to go out into the market and buy yourself a substitute piece of land.